Hello, everyone, and welcome to our live stream. This final live stream before going into the Easter long weekend. I'm wearing the closest thing I have to an Easter sweater. I've got a couple of bunny rabbits in top hats today. Before we get started, hopefully the questions roll in. There's been kind of an interesting little story going on in the news. I don't know if anyone saw. Out of New Jersey, a waiter spilt wine on a customer's purse. It was at a country club, and unfortunately, it was a $30,000 Hermes purse. So the customer sued the country club, who then in turn sued the waiter to recover the cost of the damage. In Alberta, frankly, throughout Canada, we wouldn't see those types of lawsuits be successful. We actually have pretty strict rules in Alberta about when an employer is allowed to withhold any payments or recover payments from an employee. In Alberta, we have the Alberta Employment Standards Code, which governs this type of conduct. Employers can withhold certain amounts from your pay. Those should be the obvious ones. Income tax, that's withheld and remitted right to the CRA on your behalf. CPP and EI deductions. And then, of course, things that you've provided written consent for. So if you've agreed that an employer can withhold some of your pay and put it into an RRSP on your behalf. Some employers have some, very small amounts being withheld and put into a social committee fund. So that you can have a party at the end of the year. Sometimes there's things that are employer matched contributions. So if you can contribute to a savings plan, then the employer will withhold that, put it into a savings plan, and then match it. So certainly those things are okay. It's also okay if there's a court order or a garnishment for withholdings. Your employer has to follow those if they get a notice of garnishment. Things like child support or payment of a judgment. Things that your employer is not allowed to withhold from your pay is things like a cash shortage from a till. If your till is short at the end of the day, potentially it's because there was a mistake that you accidentally made in giving too much change earlier in the day. Doesn't matter, your employer can't recover that amount from you. Loss or damages to equipment. So if during the course of your duties something gets damaged, the employer can't recover payment from you for it. If a dine and dash situation, if you're a server at a restaurant and somebody skips out on their bill, the employer can't withhold that, make you pay it. A couple weeks ago, we had somebody call into the show whose employer wanted to do a penalty on their paycheck if they showed up later. Not even late, if they didn't show up 15 minutes early, the employer wanted to apply a penalty and then charge them for that. They can't do that. The other thing that's recently come up on a file of mine is uniforms. Your employer can't withhold amounts from your paycheck for a uniform unless you've consented to that. Employers have pretty strict obligations to pay you all of your wages that you've earned. By the time you've done the work and your paycheck comes due, you've earned that money. It's actually yours. And so the Employment Standards Code has some very specific and particular terms in there about when you have to get paid. You have to get paid regular pay on your regular pay day. People plan their lives around getting those paychecks. So if your mortgage is coming out on the 2nd or the 3rd of the month, you need to pay on the 1st in order to pay it. Now, when it comes to your final pay, if your employment comes to an end, for whatever reason, whether it's a resignation, a termination without cause, or a termination with cause, the employer has to pay your earnings in a period of time. The new language under the Employment Standards Code is within whichever period of time that the employer chooses of the following two options. So within 10 consecutive days after the end of the pay period in which your termination occurs. So if your pay period is the 1st to the 15th of the month, 10 days after that, so by the 25th of the month, or 31 consecutive days after the last day of your employment. So if you're terminated on January 1st, they have to pay you by February 1st. It's the employer's election, which they choose. Unfortunately, we would love to see it that the employee gets a say in it, but it's whatever either of those options that the employer chooses. Okay, great. So if you have any issues with your employer withholding amounts from your paycheck, please feel free to reach out to us, have that reviewed. Of course, send us any paperwork that you think you might have signed. Just because you may have signed something doesn't necessarily mean you can't revoke that in signing. So please feel free to reach out. All right, so getting to the questions today. A question on Facebook from Sherry. My employment contract clearly states that I'll be employed in my specific position, including duties attached in the job description. However, my employer has told me I'm now managing another program and will be responsible for another program soon. No change in pay or hours or updated description. Is this legal? So, Sherry, good question. It obviously sounds like you have a written employment agreement. So it's certainly important to look at your duties, and as well as to see if there's any clause in your employment agreement that says that they are allowed to make any changes, because that would be sort of something that we're looking for. In the absence of an express and enforceable, that's the term. So it has to be clear and it has to be written in an enforceable way. Your employer is not allowed to make significant changes to your employment relationship without your consent. Normally, employers, they want to do positive changes like pay more money. Certainly, you're going to consent to that. But if your employer is trying to fundamentally alter your employment relationship by adding extra duties without compensation, you have a choice. You can, of course, accept the change, or you can tell your employer, I don't accept the change. And then the employer has the choice of saying, all right, well, fine, we won't enforce the change. If they still insist on enforcing the change, you may be able to treat that as a constructive dismissal. So what is a constructive dismissal? It's sort of a dismissal in effect. It means that your employment relationship in effect has come to an end because your employer is demonstrating that it no longer intends to be bound by your employment contract because it's making fundamental and unilateral changes. And so objectively, they're saying that, we don't intend to be bound by the terms of the agreement that we agreed with you at the outset of your employment. And so you have the choice of saying, well, then I also don't agree to continue to perform the employment agreement, and I'm considering myself constructively dismissed. So what that means is you would be put into a termination without cause situation, in which case you would be entitled to your statutory termination pay, which has some mandatory minimum amounts under the Employment Standards Code. And you may also be entitled to additional pay in lieu of notice, which we colloquially refer to as severance. And that severance can be up to 24 months pay. So certainly this could be a constructive dismissal situation. Now, constructive dismissal situations have to be navigated very carefully. A big part of my job and my day is spent helping employees navigate employment situations. And so the difficulty with constructive dismissal is if you haven't established that the change that your employer was trying to make was fundamental and a significant breach of the terms of your employment agreement, you could be deemed to have simply resigned from your employment, in which case you wouldn't be entitled to any pay in lieu of notice or severance. So it's always very important that before you pull the trigger on alleging constructive dismissal, you contact our firm. We can help you negotiate the situation and ensure that you're not being put in a situation that could be a deemed resignation, and that you're really demonstrating to your employer that As a result of the change that they're forcing upon you, you have no choice but to consider yourself constructively dismissed. So, we're going to provide you with some guidance on how to make sure that you're not saying, now I have no choice but to resign. That would be the wrong language that we don't want you using. Or, sometimes people get uncomfortable in the situation about telling their employer that they're forced into the situation, and they write a very lovely, thankful resignation notice thanking the employer for the time. And that can be hard, not impossible, but a little bit harder to deal with in alleging constructive dismissal once you get legal advice. So certainly contact us early. There is no downside. There is no harm in contacting a lawyer early on. I mean, we're going to provide you with the options that you have. It doesn't mean you have to take them, but you should know what options are in front of you in that situation. So Sherry, please feel free to reach out to the firm. All right, questions from Bubbly Host. I've been working at my job for well over 2 years full time. The job was quite far from my home, so I gave up a lot to take the position. I was let go yesterday by my boss and told that they'll mail me my paycheck, and that's that. Jobs in my, quote, field are hard to come by, so it will probably be a bit before I find something. I'm wondering if this is legal. So a couple of bits of information we don't have from Bubbly. So I'm assuming Bubbly is a non-unionized employee. I'm also assuming Bubbly is not a federally regulated employee. So they don't work for the bank. They don't work for transportation. They don't work for a cell phone company, and that they are a provincially regulated employee. I'm also assuming that by their final paycheck, that the employer means that they're also going to be paying some termination pay, because in this situation, if you've been employed for well over 2 years, you're entitled to 2 weeks pay. So 2 weeks under the Employment Standards Code for employees who are employed for more than 2 years, but less than 4 years. Unless there's a written term in an employment agreement that's enforceable that says that all your employer has to do is provide you with the mandatory minimums. That's either mandatory minimum working notice or mandatory minimum pay in lieu of notice, and you may be entitled to severance. One of the factors that goes into assessing how much notice or pay in lieu of notice that Bubbly is entitled to is length of service, but certainly there's other factors that go into it. Age is a factor. If Bubbly Host is 65, he or she may have a harder time finding a job than somebody who's 45. If Bubbly had a supervisory position, then Bubbly might have a harder time finding a comparable role in a supervisory role. If Bubbly was paid an excessive amount of money, so over fair market value, they may have a harder time finding a job that pays close to that amount of money. So Bubbly Host, looks like we need a lot more information in order to analyze whether you're entitled to more, but don't worry, that's exactly what our firm does. We speak to people all day, every day. I've spoken to 4 people today who've been let go and wanted me to evaluate their severance package. It's our pleasure to do it. It's what we are here to do, is help you evaluate whether your severance package is fair and reasonable. As lawyers, we don't have magic wands, and we're not out to get you the sun, the moon, and the stars. We are here to get you your fair and reasonable legal entitlements. And if you're not getting those, I mean, that is time when your package needs to be evaluated, and perhaps you have a lawyer assist you with advocating for a better severance package. All right, so Bubbly Host, please feel free to reach out and let us assess whether you're entitled to more. It sounds like you probably are, so let's see how much more that you are entitled to. All right, and so you can find out more. Our host is putting the email address at help@employmentlawyer.ca. Of course, you can always go to employmentlawyer.ca and find us on the Contact Us page. Okay, terrible tea. What is the difference if you are called a contractor or an independent contractor? This is a great question, Terrible. So employment used to be employees only, right? So you worked for somebody, you received your regular pay, and you received a T4 at the end of the year. Employment is actually on a bit of a spectrum. So, on the one hand, we have people who are a classic traditional employee, and on the other hand, we have somebody who is a independent contractor. So that is somebody who provides services to a company, but doesn't have any degree of exclusivity. So, for example, I take my car into the mechanic to get fixed. That mechanic is kind of working for me. He's providing a service to me, but he's certainly not my employee. I'm paying him, but I'm not paying him wages. I'm paying him for the service. That mechanic also has multiple different people who are coming to see him. So that would be a independent contractor. So independent contractors aren't reliant on a single company or entity for the majority of its income. Now, there's some people that are in an intermediary category. So they are a dependent contractor. They're not an employee. They don't get a T4. They usually invoice for their services, but they have a degree of dependence. So at least 50% of the money they receive is from one company. So they provide services to one company. Maybe it's 100%. That person would be, a dependent contractor. There's the degree of exclusivity in connection with that. So if I provide 90% of the services of all the work I do to one single customer, I am dependent on them. So that's the difference sort of on the spectrum. Now, some employers call people contractors, and usually they're calling them an independent contractor in a written agreement. But that's not conclusive. Most contractor agreements will call you an independent contractor, even if you truly are dependent on one provider, and you have no risk of loss or profit. You do your work, and you actually get paid hourly for it. You're either a dependent contractor or even potentially a misclassified employee. So there's a lot of contractors out there who, for all intents and purposes, are an employee. Their employer sets their hours of work, their wages. They go on break when their employer says so. They go on vacation when their employer says so. Everything about them is employee-like, except for maybe how they invoice for their work or get paid. In that case, you're a misclassified employee, and you're entitled to all the benefits that employees get. And so, overtime, vacation pay, those types of things. So I hope I answered your question, Tara, on where on that spectrum you may be. If you've got any further questions, please don't hesitate to continue to write in today or reach out to us at employmentlawyer.ca. All right, Harold. Took a new position at a different location at my employer's request with the condition of only 2 days in office due to the travel time. Can my employer later change in-office requirements? I don't think so, Harold. It sounds like your employer have a condition to your agreement. You only agreed to take a position at a new location on the condition that you work from home 3 days a week and in office 2 days a week. That's the bargain. That's the exchange. If your employer is suddenly changing the bargain, that could be a constructive dismissal, just like we were talking about earlier. You've now set what your fundamental terms of your employment relationship are, and it's pretty fundamental to say that I only have to go to the office 2 days a week because it's so far away from my house. So I would think that's pretty binding agreement. That's a negotiation in which you've agreed to give up something in exchange for getting something. And that's a fair bargain. You've negotiated that. There's a good reason for it. And you can hold your employer to that. They can hold you to it as well. All right, Terrible is back. Another question. If you have a commission structure as part of pay in your contract, but it doesn't stipulate the percentage, can your employer change this at will? No, not without your consent, So commission rate certainly can be implied by your course of conduct. If it's not written in agreement, certainly it's going to be somewhere. It's going to be in a pay stub. It's going to be in your commission sheets. It's going to have been decided. If your employer is trying to change your commission structure, the change is, a fundamental change, it's a significant decrease to your overall compensation, you have a right to reject that change. Your employer can't do it without providing you at least significant notice that they're providing the change. And if they want to make the change, they have to do it with your agreement. So, of course, if they want to change it and your commission cut goes up, great, go right ahead. But if they're trying to reduce it, the reduction will cause a reduction in your overall compensation, that can be constructive dismissal. So let me explain that a little bit clearer. Let's say you sell a product that costs $10 and you get a 1% commission. If your employer says, well, that product we're now going to sell for $20, and as a result, we're going to change your commission, that may or may not be a constructive dismissal because it may or may not affect your overall compensation. So there's always a little question about compensation when the what you get a percentage of is changing, or if it's just your commission. If you're still selling the product, it's $10, and instead of a 1% commission, now they just want to pay you a 0.5% commission. Certainly, that could be a constructive dismissal. All right, a question from ROK. I was just notified that because of org changes, they don't need my team anymore, so I was terminated. I'm 38 weeks pregnant and my mat leave was going to start in May. According to what I've been told, they're giving me 3 months of total pay as severance, however, no extended medical benefits. They were topping up my salary for 17 weeks while I was going on mat leave, but they say they can't provide that now. Am I owed anything else here? Yes, absolutely yes. Here's the problem with employers who terminate people who are on the cusp of a parental leave, in this case, a maternity leave, if they're on maternity leave or if they're just returning from maternity leave. It really affects your ability to go and get EI benefits. So even though there's parental benefits under EI and then there's regular benefits under EI, it's very challenging to sort of get one after the other because you haven't built up enough insurable earnings. And so in this case, ROK may be entitled to get EI over the same period that she was trying to get maternity leave benefits. So this can create a real financial issue. When it comes to severance, when somebody is on parental leave or about to start parental leave, normally your severance should be paid after. So if you're set to return in May 2026, because you're taking a 12-month mat leave, your severance should really start then. That way you get your everything you would be getting, your EI, maternity leave benefits, and your salary top up. So ROK, I want you to reach out. I actually want you to reach out to me. I'm very familiar with this issue. As a woman, of course, it's very important that we see equality. And this may not have been a discriminatory termination in that they're making org changes and ROK, her whole team is getting laid off. but the effect is very discriminatory on somebody who's 38 weeks pregnant and is going to have an upcoming maternity leave. So I'd be pleased to help you. Certainly you can reach out to any of the lawyers at our firm, or you can reach out to me directly. You can find me on our website. All right. Bigly G, how long does a company have to respond to a request for accommodation? I wish that we had legislation that set that out. So for those who may not be aware, the accommodation process relates to an employer accommodating a request under human rights legislation. So it's when somebody needs some changes to their employment relationship so that they can participate in the workplace. The easiest example is, of course, somebody who has a physical disability. Those are always the easiest for people to wrap their heads around. So if you've broken your leg and your employer has too many steps to just get into the entrance so you can get to the workplace, there's a process called accommodation in which the employer and the employee both participate in a process where they talk about what accommodations may be needed. Is it a ramp? Is it, some sort of system that you can get into the workplace? Now, the accommodation process should be reasonable on how long it's taking, particularly if during the process you're not receiving any benefits. So whether it's WCB benefits that are sort of cushioning you while you're working through the accommodation process with your employer, or maybe it's disability benefits, short-term disability or long-term disability. So those delays can really have a financial impact. So normally what happens in the accommodation process is somebody provides some medical information from a doctor. It doesn't have to disclose the nature of your disability, but it does set out your limitations. So a limitation would be can't lift over 5 pounds more than 5 times a day. The accommodation process is then how the employee and the employer can work together to ensure that the employee can work having regard to those limitations. So the accommodation process shouldn't take that long, although it obviously depends on the particulars and the complications, and whether the employee is providing medical information fast enough. So if you're having a situation where your employer is going on far too long and you're getting the sense that they're just stringing you along, they don't really want you to come back, they have no interest in accommodating you so that you can participate in the workplace, reach out. Often it can be considered a constructive dismissal if it goes on long enough. Of course, you can find us at employmentlawyer.ca. You can reach out at help@employmentlawyer.ca. All right. A question from Surgeon. Does documentation beat conversation? I think what you're saying is, are the terms of a written agreement more enforceable than the terms of an oral agreement? Sometimes it depends on if the oral agreement preceded the written documentation or if it happened after. It depends if the written documentation says something like, notwithstanding any other representations that were made or oral representations that were made, the terms of this contract supersede those. It could also say things like, any changes to this employment or any changes to this employment agreement or document must be made in writing. In that case, documentation reigns supreme. As a lawyer, I'm telling you, put everything in writing, even if it's an email, just I'm confirming the conversation we had. That puts it in writing. And the reason for that is, of course, lawyers deal with evidence. And so when you come to us and you say, well, I had this conversation 2 years ago with my employer, that I would never have to go back to the office. I was allowed to be a remote worker forever. And it's the reason why I forewent a promotion or another job opportunity. And then I say, okay, well, great, well, send that to me. And you're saying, well, no, I have nothing to send to you. That can make it a little bit harder. So absolutely put it in writing. All right. Well, that's all the time we have for today. It's always such a pleasure to reach out. Great and interesting questions. These questions allow me to test my knowledge as a lawyer and bring me back to some of the issues that really matter to my clients. So I really appreciate the opportunity, you guys. I'll be back in a few weeks myself, but we'll have lots of other question and answer sessions. Our next one's actually coming up on Tuesday with Sefton Lebrand out of our Ontario office. So those of you in Ontario, reach out to Sefton. Otherwise, those of you from Alberta, I'll see you again in a few weeks. Bye.